All right, so welcome to the Estate Planning Bootcamp. This is the 5th session. How many of you have been to all 4 other sessions? Wow, 1, 2, 3. Well, there's going to be a special recognition that if you make it to the 6th, which is next month, and you'll get a special benefit for you or your clients if you do show up. And what we like to do is make ourselves available to you anyway, so if you have questions on any of the things that we're talking about today, please feel free to call me or email me is better because I'm always on the telephone. But if you send me an email, I'll respond to you, at least try to give you an answer to a question that you might have on estate planning or advanced estate planning or any of the stuff that we've covered in the first 5 sessions or all the way through to the 6th session. Today is Advanced Estate Planning Essentials. We're going to really cover 3 things today. Number 1, and very important in your practice and in my practice, is asset protection planning. So we'll cover all the ins and outs of that in about 20 to 25 minutes. I've given 2-hour seminars on asset protection planning. It can be really, really complex area of law. So we're not going to try to teach you all the aspects that you need to know if you were a lawyer. We're just trying to teach you as a financial advisor the things that you should remember when you're advising your clients about trying to protect their assets and issue spotting. So the goal is to spot as many issues as you can. Of course, we'll talk about advanced estate planning techniques. There are regulations, proposed regulations that were issued by the Internal Revenue Service on August the 4th. And these regulations have a significant impact, not only on this year's year-end planning, but also on planning beyond this year. And it's really going to be a significant impact. And then lastly, we'll talk about charitable planning techniques. There are a variety of different techniques that we use for our clients. Some of them are high net worth clients. Most of the time, when we use these techniques, we're applying it to high net worth clients. High net worth clients include clients that have essentially net worths over the exemption amount. If you have a single individual, a single client, the exemption amount is $5,450,000 this year. It's scheduled to be indexed for inflation. Who knows what's going to happen after the election, but we can anticipate that at least for 1 year, the law will remain the same until the new president and the new Congress take foot. But with charitable planning, if you have a married couple, $10,900,000 is the threshold over which we really start engaging in significant advanced charitable planning. Hopefully today we're going to give you some knowledge of advanced estate planning techniques. What I want you to do, I want to encourage you to ask questions as we're going along, even if it's off topic. If I'm going to cover it later on, I'll tell you we'll cover it later on, but I want to make sure I can answer your questions. So it's not a lecture, I want to make this as interactive as we possibly can. And if you've got clients with complex estate plans who are high net worth, or if they don't have complex estate plans but should have more complex estate plans to do their planning, I want you to have confidence to engage in a discussion with them so that you can help them spot the issues and steer them in the right direction on what techniques to use and what not to use under certain circumstances. So let's start with asset protection planning. Up until about 20 years ago, asset protection planning was really reserved for those who were extremely wealthy, the ones who were worried about being sued because of the size of their wealth. Well, today, 1 in 4 people in the United States are engaged in litigation. That's a pretty significant population when we consider that only about 0.2% of the population, maybe 0.3% of the population, qualify as these high net worth individuals. So a significant amount of people are engaging or being brought into litigation. And anytime you're brought into litigation, you're going to have to hire lawyers. And anytime you have to hire lawyers, you're going to be paying fees. And even if you're not guilty or you haven't done anything wrong, or if you have been hurt by somebody, you want to pursue them. In litigation, it's going to cost you a pretty penny to go through with the litigation. So how do you protect your assets from claims of creditors, people who are after you for your wealth, even if you didn't do anything wrong? I mean, if there's a frivolous lawsuit, what do? Somebody sues you just because they want to accuse you of doing something wrong, but you really didn't do anything wrong. You represent some radio personalities. If they say the wrong thing on the air, they're going to be sued for libel or slander. And there is protection for that, and we're going to talk about how to protect yourselves from that, protect your clients from that. So, who needs it? That's the first question. We'll cover that. Who needs asset protection planning and why? When's it too late? This is where I've gotten into debates with clients where they were told by an advisor, hey, you should do this now. If you do this now, your assets will be protected. And I told them, it's too late. The claim has already been made against you, or you are aware of this claim, and creditors are after you. Is it too late? If it's too late, you may not be able to engage in some of these techniques to protect your assets. Even if there's a claim against you, you may be exempt from liability. What assets are exempt from liability? Even in bankruptcy, how do we protect our assets? What kinds of assets are protected, and what forms of ownership will protect you? Insurance is always the first line of defense. What does it cover? What does it not cover? We'll cover that. And then business entity protection. What kinds of business entities should we use for our clients or for ourselves to protect us and our clients from the claims of creditors? And when are these types of business entities not effective? When do they not work? Lastly, trusts. As all of you know by now, if you've attended any of these sessions or if you do any kind of estate planning, trusts come in all shapes and sizes. So we'll talk about the trusts that work for asset protection and the trusts that don't. So, why do we do it? What is it? What is the essence of asset protection planning? Well, we can protect ourselves from divorcing spouses if we do things right. Creditors, anybody with a claim is a creditor. From lawsuits, I've already covered that a little bit. From beneficiaries who inherit money and they spend it. Spendthrift beneficiaries. They don't know how to control a dollar. So how do you protect them from themselves and from their creditors? So who needs it? Every professional who is licensed to do something needs asset protection planning. Doctors, lawyers, engineers, CPAs, they all need asset protection planning. Employers, people who employ others, because they are your agents out in the field, and they may do something that cause liability for you. Your business partners, and you need protection from them, they need protection from you, particularly in certain business arrangements. If you enter into contracts, there may be liability that you have under your contracts that you enter into. If you put an addition on your house and you've entered into a contract with a contractor, you may have liability to them, and they may be able to collect and get a judgment against you if you don't pay them, or even if they've done something wrong, you may have a claim against them, but they may have a claim against you. How do you protect yourself? And then, of course, in personal lawsuits, very prevalent, divorce, automobile accidents, guests at your house fall and injure themselves, rental properties that you have where somebody is a guest on the rental property or you own the rental property, uninsured medical bills, or you just have a party at your house and somebody gets injured. What do you do? Why do we need asset protection? Anybody? Why do we need it? To protect your net worth. Okay, that's a good answer. Why else do we need it? To protect ourselves from unexpected liability. We can't predict everything that's going to happen to us in the world. We don't know when somebody's going to come and rear-end us, and then we rear-end somebody else in our automobile. That happened to me when I was younger on Canal Road. There was a stretch of ice. I'll never forget this. I was 21 years old, coming home from work, from Arthur Anderson and Company, late at night, and saw the guy stop in front of me. I tapped on my brakes and started to slide, but I was okay. Somebody from behind just rammed into the back of me. I rammed into the back of him. He rammed into it. It was a 5-car accident because the person going behind me was going so fast. What do? I couldn't predict that was going to happen. We can't predict anything like that. But there's potential liability because I ran into somebody else, right? Excessive liability. I like to refer to that as the tort litigator's windfall. Excessive liability, a judgment that is against you for not only damages that you may have caused to somebody else as a result of something that you did, but there could be punitive damages. Up to 3 times the amount of the claim could be levied against you in a judgment. Things that you can't predict. And then, of course, bankruptcy. If you go bankrupt, can any of you get your securities license? What happens in that event? What happens to a CPA if a CPA goes bankrupt? Anybody? Do you lose your license? It may suspend your license. You may not be able to practice as a securities broker. You may not be able to sell securities for a period of time. And it's a stigma. It looks bad. How do we avoid it? How do we protect our assets from it? What if you can't help it? If there is an excessive liability against you, how do we protect ourselves? Now, when is it too late? And this is probably the biggest area of confusion in the general population. So I had this guy call me. He was a longtime client of mine. And he called me, and there was already a judgment against him for a mortgage debt that was due on a property in another state. And they were taking him to court, and they were trying to execute on the judgment, collect on the judgment, liquidate the judgment, get assets to pay for the judgment. So the court had already found him liable. He owed this money. He said, I got a call from a guy in Nevada who was with this small bank out there, and he said, you can protect it. Use a Nevada restricted limited liability company and put your assets, what you have left, into this thing, and it'll protect it. And you can use irrevocable trusts and LLCs and all this other stuff around it. We'll protect it. What's your reaction to that? Too late. Too late. That's clearly too late. So, if you make a transfer of any asset after a creditor has a claim, it's too late. The question is, when does a claim arise? That depends on the state. There are 50 states and the District of Columbia. So there are 51 different jurisdictional rules and laws, sets of laws and interpretations that have to be consulted. So it depends on where you're located, where the assets are located. But the general rule is there's something called the Uniform Fraudulent Conveyance Act. And under the Uniform Fraudulent Conveyance Act, which has been adopted in many of the local jurisdictions, if you know or you're aware that a claim may exist against you, then a claim exists.